We have a case study for you today about handwritten wills or handwritten codicils to a will. And a codicil is like an amendment to a will. So we were hired by a proposed personal representative or executor to an estate, and she informed us that her sister had executed a handwritten note on her deathbed that ultimately disinherited two of the beneficiaries that were listed in her will. Our first concern was that the sister had executed this handwritten note. The issue being that when a will or codicil is executed in handwriting, it can ultimately be determined that it is invalid in the state of Florida because any handwriting is considered to not be valid. And the reason for that is we typically see people that take their existing will or trust and they attempt to amend it by writing on it in handwriting. So they'll maybe cross out a beneficiary's name, or they'll X out a whole provision, and they will write on it themselves and try to change it without actually talking to an attorney and having the document amended. There is a caveat though, with this particular client's case. The handwritten document was properly witnessed, and so that will actually allow us to submit it to the court and hopefully not have any issues with the court admitting it as a codicil or an amendment to the deceased person's existing will. So, we'll have to jump through a couple extra hoops because all of the requirements to allow us to easily admit the handwritten document in as a codicil were unfortunately not understood by the person that created the handwritten document. So we will have to jump through some extra hoops to make sure that we have an oath of the witnesses to state that they were actually present with the individual that made the handwritten document. But other than that, luckily, the witnesses were present in the same room as the person that created the handwritten document, and everyone signed in conformity with the law that outlines how a will or a codicil must formally be signed in order to be admitted as a valid legal will or codicil in the state of Florida. So the moral of the story is make sure you work with an attorney if you need to do an amendment to your trust or your will so that you can make sure that your documents are executed properly. Make sure that they are not in handwriting because there's always the possibility of a handwritten document being thrown out as invalid if it is not properly executed. If you need any help with getting any amendments or updating documents, please feel free to give us a call.